So my name is John Clark from the Pretrial Justice Institute, and as Katie said, welcome to our first year to have with us Roseanne Scotti, who is the director of the Drug Policy Alliance of New Jersey. And Roseanne was very instrumental in a major initiative and reform effort taking place in the state of New Jersey that is unfolding as we speak. Now, there is a document that Pretrial Justice Institute put out a month or two ago called Improving Pretrial Justice in New Jersey. And that document is basically an interview that we did with Roseanne and her responding to questions about how the reform efforts came about in New Jersey. What was the genesis of those reform efforts? The focus of this session is going to be taking it to the next step, and that is basically let's focus on the implementation of those changes that have been occurring in the state of New Jersey. January 1st of 2017 was when the changes were implemented. So we've got a few months experience under our belts, and there was a 2-year planning effort that went into rolling out these changes. So before we start, Roseanne, maybe if you could begin by just telling us a little bit about what those changes were, what reforms were implemented in New Jersey on January 1st.
Absolutely. The biggest piece was probably deprioritizing money bail. Money bail is still an option in our system, but it's a last option. We now have a hierarchy of released on your own recognizance and released on non-financial conditions as your first two options. And the judge has to go a pretty long ways to ever say that money bail could be used. They'd have to show that no other condition or combination of conditions would be effective in bringing the person back to court and protecting the safety of the community, which is a hard thing to show. We also created a pretrial services unit, which monitors folks who are on pretrial release if they're released under conditions. And we have now a validated risk assessment, the Arnold tool that is used as part of how a judge makes a decision. And if a judge would deviate from, the recommendation of pretrial services, which includes that risk assessment, they have to put in writing why they're doing that. So those were really the three big changes.
Mm-hmm. And what about the detention?
And sorry, but yes, and we now have preventative detention, which we did not have before. That required a constitutional amendment because we were a state that mandated bail. And so, yes, now what can happen if the prosecutor makes a motion under certain conditions, someone can be preventatively detained. I always like to say we had preventative detention before in New Jersey. It was just called money bail.
Oh, right.
They weren't allowed to say it out loud, but if the prosecutor wanted to detain you, they used money bail. But now, we have an honest system where if they want to detain you, they have to make their case for that. And then we also have pre-trial, we have speedy trial provisions that go along with that. So for people who are detained, there's an actual timeline with, actual numbers, not, sort of an amorphous right to speedy trial language, 30, 60 days, 90 days when you have to bring, your charge against someone and when the other side has to have discovery, all these kinds of things. And so that is a protection in the minority of cases where someone does get detained pre-trial.
Okay. And do you have any statistics showing how things have played out over the past 5 months now?
We do, and the statistics are really fantastic. Mm-hmm. What we have seen, we have like the first 3 months of statistics. We're actually hoping to get, they didn't really release statistics last month. We're hoping to get 5-month statistics sometime this month in June. Mm-hmm. But what we saw for the first 3 months was pretty incredible. There were only about 8 money bails set in the whole state of New Jersey for those first 3 months, which is an amazing shift because, this isn't just a legal shift. shift, it's a cultural shift. One of our concerns was that judges might continue to set money bails because they were used to it. They're used to looking at a bail schedule. They're used to just setting a money bail, and that did not happen. So that was, one of the biggest wins here. The other piece is that our jail population statewide has dropped almost 30%, which is just incredible. We had hoped to see that. The report we did that launched the campaign for money bail estimated that 40% of the people in our jails were there solely because they could not afford off the nominal amounts of money bail. And so you would expect to see a 30 or 40% drop pretty quickly. And we were, again, heartened to actually see that play out in reality. We also saw that, one of the things we were concerned about was that, with the preventative detention piece, that was a lot, I think, for people to wrap their minds around. Even though, as I say, we had preventative detention, we just called it money bail before. So to say that the state's going to have the ability to preventatively detain people under certain circumstances, you want to make sure there's safeguards, and you want to make sure that it's not going to just be rubber stamped by a judge every time a prosecutor asks for it. And what we saw was about 55 to 60% of motions for detention were granted by a judge. So we're really seeing that the judges aren't rubber stamping this, that they're really, doing what they should do in providing individualized decisions and individualized justice. And sometimes they're just flat out saying, no, the prosecutor is, is asking for this, and they can't really make their case. So that was very exciting.
And do you have figures on how often the prosecutor was asking for detention? That was a small number to start with, wasn't it?
Yeah, we know that I believe it was about 20% of the time, maybe a little less, maybe 18% of the time. And the percentage of time when people are detained is about, it has varied a little between like 9 and 12%, depending on the county and things like that. So we, again, know we would like to keep it low. We're going to keep our eyes on making sure that doesn't go up as we move forward. But, we were expecting, in the best case scenario, an 8 to 10%, level of preventative detention, and that's what we're seeing. So again, that number was in line with what we, worked for was really gratifying.
Yeah. So you talked about how that figure worked out the way you wanted it to, and the figure for the reduction in your jail population has kind of worked out the way you wanted it to. What about the idea of 8 defendants throughout the entire state in the first quarter of this getting a secured money bond? If someone had told you that a year ago, that you would only have 8 money bonds set in the entire state, what would you have said then?
That was the one I was most surprised about, simply because, as I say, it's a real culture shift. It's not just a legal shift. Judges are used to setting money bail. They've set money bail pretty much for the history of our state. And, it can be really challenging to shift those kind of cultures. And so that was really was the most surprising number. And I think it's a real testament to our administrative office of the courts. Here in New Jersey, we have statewide oversight of the courts. And, there was a 2-year period where they, for them to implement this, the law passed 2.5 years ago, and they had 2 years to get this up and running. And they were incredibly busy, and they really did a fantastic job in terms of training and educating judges and prosecutors and public defenders. And, it really showed when we got those first few months statistics, because people were saying a lot of the right things over the last 2 years. People were saying money bail will really go away. Money bail is not going to be an option. But again, when, you hit the button and things go live, to see that change had really, sunk in and had taken was, again, really a wonderful and gratifying experience, but also a little surprising. Yeah.
Now, we do have a question here that's come in about those 8 defendants who had the money bond. Is there anything about those 8 that kind of stand out? Were they all very serious charges? Was it appearance issues? What was it that And was there any commonality that you could find?
We do not know at that point, at this point, just because of the level of detail that we got or didn't get in terms of what AOC released in terms of their data. What we are working on, along with ACLU New Jersey, is that we're doing a data request from the courts. And we're hoping to have some of this in June or July, and possibly release a report in September where we do a deeper dive and look at exactly those kind of things. What was it about those 8 people? You know, we're going to be looking, you know, overall at things like racial disparities in terms of, you know, preventative detention, but also the level of conditions people get when they are released pre-trial. So that's something we're going to be looking at, and we'll have more information soon.
Okay. Now, for you know, you were talking about how the judges in New Jersey have come about, you know, this great cultural change that took place. What would you say to other jurisdictions that are trying to do the same sort of thing, that they want to implement a major change? You know, you're going to have to do trainings. You know, you're going to have to you really shift culture on it. What do you think led to your success in order to get the judges there to make those changes?
Well, what I would say to people, first of all, is to talk to our administrative office of the courts and, you know, find out just exactly how they rolled this out, because, you know, they really did such a great job. And I think they really lead the country now, because, I mean, this was such a huge shift. It was not an incremental shift. It was really a visionary major shift in what we did. And so, you know, in terms of the technical details of how many trainings they did and when they did them, you know, Judge Glenn Grant, who's the administrator for our Office of Courts, could talk to that, and some other folks. And also, obviously, our Supreme Court, you know, there was a rules committee that put together rules for this. You know, so, and again, they would all, you know, they could, you know, I would ask any state that's thinking about how you did this to go directly to them and talk, because I also think that, you know, a sort of peer-to-peer approach and having them have a level of comfort, that's certainly what, you know, we did when we were advocating for this law, was to, you know, get some of our court folks and some of our legislators to reach out to DC and to Kentucky, and also the federal jurisdiction here in New Jersey, and talk to them so they can get, you know, they're really detailed in the weed questions answered. And, you know, we're hoping that our court system folks are going to be, you know, going to conferences around the country. And so far, they've certainly been responsive in talking to people who reached out. But, you know, I think you can't rush it. You know, I will say that as an advocate, when there was a point at which we were deciding when this law becomes effective, you know, is it 3 months, 6 months? And when it was 2 years, I will say we were a little disappointed. We thought 2 years, that's a long time, you know, to wait for justice. It's a long time for people to sit in jail, for families to wait. I think, though, that it paid off in terms of having a really smooth rollout and an effective rollout and getting what we really wanted. So I think that planning process is key.
Okay. Now, the Drug Policy Alliance is a member of something that's called the Pretrial Services Program Review Commission, which was established as part of the law that implemented this. Can you tell us a little bit about what this commission does and what role it played in the planning and implementation?
Absolutely. The commission did not really play a role in planning, because the commission also went live when the bill went live, when the law went live. Okay. So we had our first meeting about a month ago. We will have a second meeting mid-July. And it's a lot of system folks. There's folks from the Attorney General's office and the administrative office of the courts, and some prosecutors, some public members. I think one of the keys is that there's 5 advocacy groups, us, the ACLU, the NAACP, Latino Action Network, and New Jersey Institute for Social Justice, that are part of this commission. And what our charge is to review the annual report that the courts are going to put out, you know, to look at what's happening around the country, and to make recommendations and reports back to the legislature on an annual basis. And I think, you know, one of the key things about this is that it keeps the advocates involved, because I mean, this was really an advocate-driven campaign to make this happen in New Jersey, and these were the folks who showed up at the State House and who, you know, were on the front lines in terms of educating legislators. And I will say it was absolutely the key thing in terms of beating the commercial bail industry, that we had such a powerful coalition. And so, you know, those folks deserve to be on this commission and to, you know, make sure moving forward that things roll out as they should roll out, and that we don't see things like racial disparities, that if there need to be some sort of, you know, they're going to continually validate the risk assessment tool, but, you know, to make sure that happens and to make sure things happen in the right way. And so we're very excited that we continue to have a voice in that, and also a platform to speak out.
Okay, good. Another question that's come in is about the 21 counties in New Jersey. So do they have their own pretrial agencies, or is this administered by the state? How does that work?
We're a little unique in New Jersey. I don't know how many states have a system like this, but we have a centralized court system. So the pretrial services will be run out of our centralized system, but there'll be people in the individual counties, because, you know, the AOC has, you know, people who work across the state, you know, staff working across the state. So I think this makes it a little easier for us, that each county doesn't have to set up on its own the pretrial services unit, that what they do and how they do it will be centralized and consistent. But I know and this was also one of the things that made it easier for us to get the statistics we needed when we released our report pointing out the flaws in the system 4 years ago, was because we have centralized reporting and centralized data collection. So it is centrally located, but there are certainly people in each county working on it.
Now, are the employees, if they're state employees then?
Yes, they're state employees.
Yeah, okay. So each county has its own, though, agency, but they're state.
Yeah, I don't know if you could say
their own staff.
Staff from the administrative office of the courts, from the pretrial service unit, yes.
Yeah, okay. Now, you talked a little bit earlier about the you know, relatively small percentage of defendants who are being held without bond under the detention statute. One concern that we hear raised a lot by jurisdictions that are considering implementing a detention provision, like New Jersey has, is that they think that it's going to be a large number of defendants who are going to be caught up in that. So instead of having half your defendants sitting in jail on bonds they can't afford, you're going to have half your defendants sitting in jail without bond. And that troubles a lot of people, and understandably so. What would you say to those jurisdictions, based on your experience in New Jersey? How did you make sure that it was limited to that small
Well,
number?
you know, again, that I will say that was one of the biggest pieces that we as advocates had to wrap our minds around and come to terms with when we started this campaign 4 or 5 years ago. And it was something that was raised with our coalition partners. And it simply takes a while, and it takes getting into the weeds of what's really happening. I mean, the fact that we could show, you know, with hard numbers, that 75% of the people in New Jersey's jail system are there pre-trial rather than serving a sentence, and that 40% of them are there just because they don't have money, often small amounts of money. And, you know, I think also educating people that, you know, we have preventative detention. We call it money bond. And what the prosecutor does is they go in there and with a wink and a nod to the judge, they say, I think this person won't come back to court, even if the person has a family, even if the person has whatever it is, for whatever reason they decide to keep them, and they say, you know, $1 million bond, or, you know, $500,000, or it could be here, you know, for some of our folks, $5,000 might as well be $1 million. And so that already existed, and people were able to grasp that. I think you do have to be really careful. I mean, I think we lay out in the legislation when, you know, someone can be detained, the level of proof that there's clear and convincing evidence that nothing else is going to serve to bring this person back to court and to keep the community safe. I think that's very important. It was very important, the court rules that our court system came up with, our Supreme Court. And like I say, it was. I will not say it wasn't a little scary to go down that road, but when you really look at what's happening on the ground, and we knew that people were being detained, and the system we had was just horrific in numbers of people being detained. And I think again, we're very comforted that the number of people who are now being detained under preventative detention is about 10%. And they have safeguards in place to protect their rights and speedy trial. And the prosecutor has to make a case now. The prosecutor can't just with a wink and a nod say, this person won't come back to court, so I ask for, $1 million bail. Now they have to really lay it out. The person has their defense attorney there who can argue back against this. And so, I think look at that piece and look at how it works out in other states. I just think, in D.C., taking a look at that, I mean, that's often the gold standard because they've been doing it so long. But certainly, in looking at what has happened in the first, 3 or 4 months here, I think that would give a level of comfort to people that if you do this right and have the right legislation and the right court rules, you're not going to see, 50% of people being in jail, because they have preventative detention rather than not enough money.
Yeah, another concern that's raised in regards to detention is, you talked about the burden that's on the prosecution. All those hearings and the length of those hearings and the time and all that. How has that been playing out? Has that gone according to plan, or is it more or less than what was expected?
At this point, it seems to be going smoothly. Like I say, we're talking about a relatively small number of people at this point. And because, in New Jersey and in this country, criminal cases often take so long, it'll take a little while before we really begin to have solid data on that. But from what we're hearing, anecdotally, it hasn't been a problem. There was some litigation about how early a prosecution has to give discovery to, the defense attorneys, and that actually came out on our side. The courts ruled that it had to be earlier, which again was a very comforting ruling because they're not rubber stamping this and simply saying, oh, well, the prosecution just doesn't have time to do this, so, we're going to make a decision on preventative detention without that level of discovery. I think, there have been some things where the courts have come down in a different way. I mean, there's been a small body of litigation at this point, but as we move, it has seemed to play out so far in a very fair way and hasn't seemed burdensome at this point.
Okay. Another question coming in regarding to detention, with the removal of the financial preventive detention, holding people on bonds they can't afford, how are judges addressing failure to appear warrants?
We're not, again, we don't really have data on that yet. AOC is going to have hopefully preliminary data on FTAs and new offenses committed while people are on release, about the middle or end of this month. So we just don't have it's been such a short period of time. We just don't have the data. And again, anecdotally, we're hearing different things. I mean, there's certainly been cases where the judge is, people have been released, have committed a new offense, and the judge has again released them. We haven't heard too much anecdotally about how they're handling the FTAs.
What kinds of concerns came up during the planning process, like financial concerns or work volume concerns, or concerns about what the public, how public might react to some of the things we're going on? What kind of concerns came up, and how have those concerns been playing out?
The biggest concerns that came up in the planning process, other than us making sure that the court rules were, aligned with the legislation and things like that, was financial. I think that, the legislature appropriated about $22 million for like the first couple years for the court system to implement this new pretrial system. They're definitely going to need more money in the future. We believe there'll be cost savings as we move forward. And so, that's going to offset this. But there was some concern about money. There remains some concern. I think the Administrative Office of the Court has done an amazing job with the money they had, obviously, based on how this is rolled out. I think they've been working very, very hard over the last 2 years years, and they continue to work very hard. They have been able to hire some new staff, so again, hopefully this will level off. We also had an interesting case. We have an association of counties that represents county interests, and they had actually been supportive of bail reform as the legislation was moving forward, because they'll save money because they pay for our county jails, and so if there's fewer people in jail, they could have cost savings. But when it came to the implementation piece, there were some costs to them. For instance, now you have to make a release decision within 48 hours under our law, and so now they have to keep the court open on Saturday, and so there's some new costs associated with that. Although there's also video conferencing and things that are being implemented to even offset those kind of costs. But in any case, the Association of Counties actually filed a suit with this state commission we have that looks at what are called unfunded mandates, and they tried to make the case that this was an unfunded mandate. It was pretty clear they were going to lose, because one exception to this is anything that involves a change to the Constitution, which our bail law did. And so they made the case. They did lose. It got thrown out. But it's continued to be something they have raised. I think there's some validity in the fact that they need some funding. But I also think one of the interesting, just practical things that happens whenever you implement any kind of new system, not just in criminal justice, but anywhere in a state, is it's a chance for people to say, hey, we'll need more money to do this. So I think it's part of the ongoing negotiation that always happens in these situations. And, at this point, it's getting implemented. They continue to complain a little. And I think there'll probably be some steps in the legislature to make sure they get a little more money. One of the things was, our Senate president put in a bill to create 20 new judges to help with this, and the governor signed that bill, so they'll be getting some new judges in the counties that are most, have the highest volume in terms of criminal cases. But it has not derailed anything at this point, but it is something to be aware of.